Okay, why don't we go ahead and get started? Welcome everyone to our panel discussion on best practices for active private fund investors. We think this is going to be a very exciting discussion. Super excited to be here. My name is Arinze Onuga. I am a senior associate at Sullivan & Worcester in the New York office. My main practice is in private investment funds. So we assist institutional investors that are investing in private equity funds and other private funds, as well as assist fund managers in establishing those funds. I thank the American College of Investment Council for inviting me to moderate this wonderful panel discussion that we're really excited about. I want to make a couple of disclaimers and announcements before we dive into the discussion. For one, we're not going to necessarily abide by every single slide in perfect order. Okay, we're going to have slides and we're going to have bullet points for you all to chime into, but this will probably be a bit more of a free-flowing conversation. So just keep that in mind as we progress. Another thing to know is that there will be four codes if you would like to get CLE credit. It's going to be an overall course code, and there's going to be 3 separate individual codes. I will give the codes throughout the presentation. So please pay close attention. I'll read the number twice each time, okay? If you have any questions, please use the Q&A function in Zoom. So just go ahead, type your question in. We're gonna save questions for the end. We will do our best to tackle each question that comes in, and we'll do it in the order in which you submit the questions, right? Let's talk about the agenda for today. So first, we're going to talk about key fund agreement terms, right? Then we're going to go on to side letter do's and don'ts. Then how to be an effective LP advisory committee member. Then we're going to talk about fund restructuring, but particularly talking about continuation funds. And then we'll move on to LP considerations in the wake of COVID-19. So we have a pretty aggressive agenda. We only have about 55 minutes to get through it all, but we will do our best to get through it all. So I would like to take this opportunity now to introduce our wonderful panelists. We have Lee Sapir. Lee is Senior Counsel at Thrivent Financial for Lutherans and its Asset Management Law Department. In this role, she provides legal advice for private equity investments and real estate investments with a specific focus on middle market buyout funds and direct co-investments. Welcome, Lee. Happy to have you.
Hi, everyone.
We also have Monica Rox. Monica is the head of private equity at AIG. Monica has approximately 18 years of private equity related experience and is responsible for oversight of AIG's private equity funds portfolio. In her role, she has provided guidance on anything PE related. Welcome, Monica.
Thank you.
Hello. Please take a moment to read their fantastic bios. I just want to keep the conversation going, but we have a wonderful panel here. In true attorney fashion, we do have a disclaimer. So I would like to read out loud. Please note that the views, thoughts, and opinions expressed by each speaker belong solely to such speaker and not necessarily to the speaker's employer, organization, committee, or other group. All information provided by the speakers and otherwise during this presentation, including the materials in the slides, is for informational purposes only and shall not constitute and have no intention of constituting legal or other advice on which you may rely. Okay. Now we're going to go on to fund agreement terms to negotiate. Private funds are generally documented as far as the organizational structure in what's called a limited partnership agreement. There are some funds that do have limited liability company agreements, but for the most part, you'll probably see the traditional quote unquote gold standard of agreements being done in a limited partnership agreement. Now, I tell you, we probably can seriously have 5 CLEs about the terms that go into fund agreements, but we're just going to try to focus on a couple of the key ones that are oftentimes negotiated and battled between general partners and the investors that are coming into the funds. We're going to start with key persons. So, Lee, I'd like to start with you. Why don't you just, first off, just explain what a key person event actually is, and then kind of go into some of the things you think about on behalf of Thrivent when it comes to investing in funds and dealing with key person event issues.
Perfect. Yeah, absolutely. Hi, everyone. Good afternoon. I wish we could do this in person, and I wish I could see all your faces, but it's nice to be here. So a key person essentially is, usually someone who works for the sponsor or someone who is the sponsor. It is varying from 1 to 5, 6, 7, even. I've seen individuals who are really critical to the management of the fund itself. The importance as it relates to key people is making sure that those people are providing sufficient time, attention, and devotion to ensuring that they are making proper investments, doing the diligence, and really providing their fiduciary duties to the fund and the limited partners themselves. So a key person event is really critical because it gives the limited partners a remedy to the extent they find out that those key individuals are no longer providing such time, or which is something that is critical when I look at this component, is really ensuring that those individuals maintain alignment with the limited partners. So, a key person event, obviously time and attention is a critical component, but I also really pay attention to change of control triggers. So when I look at the key people, I try to look at how much they own of the general partner or the management company, what their role is, and then I try to make sure that we tighten up the key person event to also relate to a potential change of control so that you ensure that they're not letting go of their economics or their voting or their control rights up above that general partner or manager level. Because obviously, the ripple effect of that could really have pretty serious consequences and implications on the limited partners and just the overall objectives of the fund itself. So, that's kind of when I zoom out and I look at a limited partnership agreement, I'm really looking holistically both at the individuals and the events. I work very closely with the business team when it relates to an analysis of the key persons themselves and the events themselves. It varies, obviously, if it's an emerging manager, if it is a young team, if it's a team that has a succession plan in place that needs to be captured in the documentation. So there are a variety of issues that you want to kind of address at the onset. Oftentimes that means a very candid conversation with the sponsor and their long-term plan and growth. And it helps us at least identify who should be on the hook and whether those people should stick around if there's one particular individual or a variety of people, just to ensure that the fund is running smoothly. And oftentimes, as a lot of people know, private equity investing is very relationship driven. You want to make sure that if you're investing because you trust a particular individual or group of individuals, those people stick around. So
Right, absolutely. And to touch upon something you said about the idea of figuring out if it's a one person or a couple of people when it comes to key person events. These key person events can be described in a number of different ways. It's definitely not a one size fits all. It could be if this particular head person that everyone knows is finding and sourcing these amazing deals, if that person fails to satisfy his or her time and attention requirements, or if 3 or more of other individuals that are pretty active but are not the head honcho, right, don't satisfy the time and attention period commitments, then there's a key person event and there's a trigger. And it's really important for the business people to really know that, right? I mean, I myself, I'm an attorney, right? I'm representing the client, and I don't really know who necessarily is really important, who may have been important and are turning to be less important. You just don't know. And you certainly can't just rely on the documents and assume that the general partner is getting a route. Monica.
Sorry.
Lee,
I was going to say, I think that's absolutely correct. And just a little anecdote, I'm looking right now at a document that's an emerging manager that has one key person, and that's it.
Wow.
And, it's really important in that circumstance to think about the future of the sponsor and the next fund and setting the documentation up to address the fact that likely, hopefully they're gonna get bigger and they're gonna grow and they're gonna have new additional key persons. So again, you have to take a real holistic approach to the analysis overall.
Yep. But before I jump to Monica, I want to give the overall course code right now. So the overall course code is 28763. That's 28763. Okay. Monica, what are some of the kinds of consequences you like to see when there is a key person event? How would you like the fund manager to be restricted or otherwise if for whatever reason the really important individuals that we want managing this fund, managing the investments, do not commit to do so?
Well, I think the most obvious one is the suspension event, right? And I think the struggle that I have with the suspension event as the terms are changing today is that they can still do follow-on investing.
Yeah.
So my view is that, there's a change. There's something that you're investing in people when you're investing in funds. And if those people disappear, you need to reset and think and take a pause on that situation and completely understand what are the consequences of that happening. So from my standpoint, I want to see, a real suspension event that gives you enough time of 180 days, that gives you enough time to kind of take a step back, understand what the situation is, and figure out if you're still covered. Now, in certain circumstances, there's enough key men that if it triggers, depending on what that second layer is, because I think that's the other thing you have to keep track of is the analysis of, okay, maybe these people aren't key people today, yep, but that second layer is strong enough to take over. But again, I think you need that pause to figure that out as you go through. So that's a key thing for me.
Absolutely, great point. And for those who may not be particularly sure on this, as far as what a follow-on investment is, when Monica's referring to it. So a follow-on investment is the fund has already made an investment in a portfolio company, and now they might want to make a double down investment, right, to maybe maintain their ownership at 20%. There could be situations where a portfolio company is offering interest over a period of time, and so the fund manager wants to make sure the partnership's ownership maintains at, say, 40%, 50%, whatever the case may be. Or they might want to do a follow-on investment in one of their affiliated, one of the portfolio company's affiliates. So there's this idea of, well, we already invested in this company, so we should be able to continue to do so. But with these follow-on investments, institutional investors oftentimes ask for a cap on that, right? Maybe 20% of the aggregate commitments of the fund can be towards follow-on investments after a key person event for a reason that obviously Monica and Lee have expressed.
And if I may just mention one other point as it relates to key person, I think the other thing you have to be very careful of as it relates to the term of key person is the ability to replace that key person, yep, with, through either the GP having the right to do it themselves or the advisory board being able to do that and you being comfortable that they can replace a key person so that it doesn't trigger.
Absolutely. Absolutely. Right on. And also, how does the suspension work? So the suspension automatically terminate and we go right back into investing if, say, the majority and interest of limited partners don't vote to terminate the commitment period permanently, or or should it be an affirmative vote that has to happen by limited partners in order for the termination to be made? And sometimes that's oftentimes a fight. We like to see, as when I'm representing a limited partner, I say, I want the suspension period. If you don't get the vote you need, it automatically terminates, right? So GP, do what you have to do to galvanize your people and convince your limited partners that, listen, I know we have a key person event, we will figure it out when we're going to get it done. And unless you all agree that we keep this thing going, then the suspension period will result into an automatic termination of the commitment period. Yeah. All right, let's move on. Lee, I know you got some good things to say, but I want to keep going so we don't lose track of time. So on to fund and investment period termination. Usually this comes about in two different ways. Either there is a for-cause termination of the fund or the commitment period, or there is a no-fault termination, right? Obviously, for-cause means we have certain events that take place, and once they take place, limited partners can vote and say, you know what, we're going to terminate the commitment period or terminate the fund. Whereas a no-fault means the limited partners come together and say, you know what, we're going to just terminate the fund. We don't have to rely on a particular event happening in order to get it done. Lee, what do you think are the market kind of LP voting thresholds when it comes to for cause terminations?
Well, I think we probably should step back, and maybe this entire presentation should be against the backdrop of the market being quite general partner friendly.
Yes.
So, I think that's an important caveat, because that has changed over the course of the last decade, and the lens through which we see a lot of what we're talking about right now is exactly that. So I think that's kind of just one thing to note. So, in again, holistically looking at a documentation, it's really important to find balance between no fault and for cause termination, but also make sure that the percentage thresholds are appropriate. I think there's a pretty wide range of, majority to 75, depending on, but I do think it's important to see what the remedies are across the board, and then decide whether the percentage makes sense, in light of what the LPs really have at their disposal, to the extent they want to pull the plug. And again, I think it's critical to really balance, we're seeing limited partnership agreements that really are just very slowly stripping away limited partners' rights to make decisions, to boot the general partner, which I know we'll talk about a little bit later, and to decide, to call it a day on the fund itself. I think what unfortunately maybe gets lost amongst the lawyers sometimes is that it's really important to think of when these circumstances come up.
Yes.
And I think that there's this assumption that a no fault right is something that limited partners would kind of cavalierly take and use. And I don't think that's the case. I mean, they're investing their money. They want to put their money to work. There's no desire to get to a place where they feel the need to do that. And I think oftentimes the conversation with sponsor counsel, is very much around the extremes of those scenarios. But really, if you look at the practicality of the matter, it is so rare for limited partners to wake up, gang together, hit a 75% threshold, and decide that it's not working. I think it does take activity that's happening behind the scenes. So again, I on the one hand, as a lawyer, I could say just run and push for the max percentage, but I think it's really important to look at it practically speaking, from an investor's perspective, to approach it kind of with that thought in mind.
Absolutely. I mean, that's a great point. And I think that this idea of looking at a for cause termination as a very viable option is also a bit misleading, right? You'll find in these provisions, it'll say the general partner conducts, let's say, gross negligence or breaches a fiduciary duty, and that needs to be determined by a final non-appealable court. I mean, everyone knows litigation does not happen quickly. So you'll probably be at the end of your fund by the time you get this conviction, right? And think about the exhaustion of going through that process, possibly for years, as your fund is still being managed. And the commitment period might be over by the time you come to a conclusion. And so it's really important sometimes in those situations where the for cause event is so restrictive, right? That you have this option to say, listen, we don't have to get to a point where there's a final non-appealable court that concludes this is a problem without being able to back up, right? And saying, we just want to step away. And sometimes there are events that might be a little bit uncomfortable for the limited partners that the GP might engage in that may not quite constitute a clear for cause event, but makes the limited partners, perhaps for moral reasons, want to take a step back and say, I just don't want to be associated with you, GP, for what you did.
Yeah, I think that's absolutely accurate. I think the cause threshold, and again, over the course of the last decade, has just become, just something that's unattainable almost. I think it's very rare to hit that definition. The scope has just become more and more narrow. Most people are tucking in the word materiality, every other word.
Yes.
It's just very challenging to work against that. So again, I think the approach has to be holistic. So if you don't have no fault remedies, then you're going to want to dig into that cause definition and make sure that it's something you can work with in case there's an issue. If you do have no fault remedies, then maybe you're a little bit more willing to kind of, accept what the sponsor is given to you. So it's just a balancing game.
Agreed. Monica, I don't want to control what you say on this. Of course, please feel free to jump in however you want, but it'd be nice if you could also chat a little bit about cures for cause events and what cures you think are acceptable and may not be so acceptable.
Cures of cause. Well, I guess if it's one individual that you can isolate and replace,
Yep.
then that's okay.
Yep.
I think it's hard when there's some type of fraudulent event that happens. You need to kind of understand, who's involved, how much is it penetrated within the fund to decide what cure or not cure. So I almost want to wait till the event happens to kind of make those decisions instead of in the forefront. But going back to the other part of your conversation, and the fact that there's this double materiality and all this stuff
Right.
going on, and cause isn't really useful. At the same time, I want people to understand that you still need to push for these things, and you still need to have these remedies in place, and not just feel like it's an upward battle and you shouldn't fight for it. Because I think that's one thing that we're struggling with today, is we're just not getting the appropriate amount of fight against these terms.
Yep.
In order to get more of a balance. And as we said, I mean, it's very much swinging towards the GP, and it gets very uncomfortable to try to, from my seat, to try to get, these investments through without the comfort of having some type of governance.
Totally agree. I mean, you can say whatever you want to say on what one constitutes to be market terms, but at the end of the day, if the general partner has a fund that is oversubscribed, there's but so much you can really ask for, right? You're not a major anchor investor. They're raising a $600 million fund. They have 1.1 billion coming their way. They're cutting you back, if anything, and you're sitting there pushing for these for cause triggers that the investor that's coming in maybe twice the amount you're coming in is saying, I'm fine with it. It's a really important point that that both of you have noted there. I mean, it's so funny because I just recently reviewed an LPA that was this was like a fund 8 of the general partner. And it was so clear that it was from back in the day, right? I started seeing terms, it's been about 1.5 years since I've seen this, right? And I realized just over the course of the past 2 years, things have significantly progressed and changed a bit in the favor of the GPs. I wonder, even the global pandemic doesn't seem to be changing that too much, particularly for the GPs that are in that upper quartile as far as returns go.
But you know what? Some of the GPs are very relationship driven, and even though they're oversubscribed, they will work with you.
Yep.
And the ones that won't, you almost have to worry about, because some of these things you're asking for, like for cause triggers, it's for cause. Some type of fraud happened, and if they're not willing to do that, then are they thinking of committing it? And we've passed on managers because of those situations. I mean, you have to remain disciplined. I think it's very important. Great point.
I'm going to stop right here and give the first code. You already have the overall course code. This is the first non-overall course code. The number is 50821. That's 50821. Okay. I just want to briefly touch upon extensions of fund terms. We usually see that a fund term is about 10 years. So most funds are about, let's say, 5-year investment period, then about a 5-year period to divest investments. And at the end of that 10-year mark, the general partner might have the right to extend the fund by 1 year, 2 years. Sometimes you have the limited partners that may have a right to have a right to extend the term, or rather the GP needs the limited partners approval to extend the term, or the LPAC to extend the term. How do you two feel about fund extensions? Do you think that, listen, if you're going to have to extend the fund, the limited partner should always have a say, or the advisory board should always have a say? And also, what's your take on whether the GP should still be collecting management fees during that extension period?
I'll start. So from my perspective, 1 or 2 years. These funds last basically 15 years if you think about it. So an extension 1 or 2 years by the GP, it doesn't matter from a business perspective, in my opinion. And then if there's any further extensions, then clearly LPs need to vote. As it relates to management fee, it really depends on how many assets are left, right? Because you want them to still continue to manage these assets out.
Yep.
But you have to balance that with, are they just trying to, clip a coupon as it relates to the management fee, or are they working through this? So I think at that point, after year 2, then you negotiate and you figure out, okay, where does it stand at this point? Do we feel like they have 5 or 6 investments? We want them to work this through. As you guys said earlier, none of us want these assets. We've hired these managers to manage these assets. We want to avoid any reason to take them back. So, that's my view on it.
Okay. Let's move on to GP removal. So we talked about for-cause terminations. Oftentimes, the same bad acts that constitute a for-cause termination of the fund will also constitute a for-cause removal of the general partner. One thing you don't see on this slide is our felonies. And I know we talked about a couple of different, you see a couple of different bad acts that are potential bad acts, so to cause a GP to be removed, fraud, breach of LPA. But these days, I've been finding myself oftentimes fighting a little bit on this felony inclusion. And just wanted to get your take, Lee. How important is it to have, let's say, a felony as a for-cause termination of the GP when you already have things like willful misconduct and fraud and some other bad acts that might somehow fall in line with potentially constituting a felony? And then also, I would just love to get your general perspective on some of the key terms that you like to see when it comes to a GP removal, particularly like the carried interest haircut and other related terms.
Yeah, sure. So this is a big sticking point for me personally. I think we've all been around long enough to see that the no fault removal of the GP is just doesn't exist anymore. And so, I think what's really important here, and what sometimes maybe the business team doesn't fully understand, is you really still want the option to take the GP out and bring in someone else, because dissolution is not an easy decision, but it's also a decision that isn't always ideal.
Right.
Think about now, we're in a global pandemic. You don't know kind of the what's going on in the background. So you do still want to have this option. As it relates to your question about felonies and the like, again, you're talking to someone who probably, if it were up to me, I would make the cause definition as LP friendly as possible. I think
Right.
that as Monica said, we're investing in people at the end of the day.
Yep.
And if those people are out there committing acts that are inappropriate, or that do or do not have a direct impact on the partnership, and I think that's a really important distinction that sponsors try to make sure there's kind of this material adverse effect on the partnership. But sometimes those bad acts, even if they don't have a direct impact on the partnership, they have an impact on the sponsor, on the name,
Yep.
on the reputation. So it's
Yep.
really important to think through all of those things and really have the appropriate remedy, because we could go to court on what a material adverse effect is from the LP's perspective, as opposed to necessarily from the GP's perspective. So I do think that there's flexibility. I'm not saying that, a driving citation should be caught up in this definition by any means, but
Yep.
I do think it's important to really see this as people behaving and representing you appropriately and conducting themselves in a manner that, that makes sense.
You raise a very good point with the idea of, does this bad act have to have a material adverse effects on the fund? That's a big one. And you have to take a step back and ask yourself, investors investing in funds, is this act in and of itself just enough, right? There's headline risk. This may not necessarily, you can have a fund manager that's doing a phenomenal job. We, not too long ago, had a client in the same situation. Fund manager, apparently doing a great job. investing aggressively, no issues from an economic standpoint. One of the folks who are considered a key person did something that was pretty egregious, and it wasn't clear whether it was really a cause event. It just left LPs in an uncomfortable situation.
Yeah.
And they have to answer to their investors as well. Many LPs are fund of funds. So their investors are saying, wait, we're stuck in this fund where this individual did X and we can't get out of it. So it's not always just about the LP, it's about the LP's investors as well. So you really have to walk through those different scenarios and figure out what are you going to push for and what are you not going to push for. Maybe not every single cause event can stand alone, right? Maybe there are some ones that are worse than others, right? One's a little bit weaker, maybe a material breach of the LPA. Okay, maybe we'll take it has to have a adverse effect on the fund, but the other ones maybe not so much, right?
I agree with you 100%. And once the cause event happens, then the question is, how hard do you slap the sponsor on the wrist? And I think, obviously, it hurts to have a haircut, but it's critical. I mean, that is their incentive. It's the money going into their pocket. Obviously the three of us kind of circled up before this presentation and shared some war stories, but there's some sponsors out there who think that it's okay to not have a haircut at all, who just get to walk with the large amount of money, no matter what they did, and even if it rose to the level of cause. And so, in terms of where the market is sitting, I think it's probably between 25 to 50% haircut, although I have seen a lot more 33 and a third kind of pop up here and there. But even 50%, depending on what was done, when you think about it, practically speaking, it's just absolutely insane to think that they get to kind of play with fire and walk away with economics as if nothing happened.
We rarely see 50%. We're lucky to see 75%, and most of the time it's 100%. And it's getting so egregious these days that they're not even becoming a special limited partner ultimately, and getting paid out over time. They want to get paid up front, or if they don't get paid up front, they want a loan. And then on top of that, they want interest on that loan. And those managers, we've literally passed on 2 managers because of that. How, in what right mind do you think that you should be getting interest on top of even getting a full 100% of your carry? It's just very egregious. But these high quality managers think they have and think they can get away with it. It's
yeah. I mean, yes, the market is certainly pushing in a certain direction. I just want to give a little bit of backdrop for folks who may not be too familiar with LPA terms. When we're referring to carried interest, we're talking about the profit that the general partner will earn in a fund. So typically you have a distribution waterfall where the limited partners, so they put in $100, they get their $100 back, oftentimes plus a preferred return. And then the general partner gets it like what's called a carried interest, which usually is about 20 to 25% of the profits thereafter. And so if a general partner gets removed for cause, doing something that's really heinous, the question is, do they deserve to get all of that carried interest, right, prior to their removal? And so it's incentive to prevent them from not doing a cause event by saying, well, if you do get removed, you're only going to get 75% of that interest, right? That's what we're talking about. We're saying the haircut. And so nowadays we're seeing more like a 25%, maybe 33 and a third percent reduction. Whereas there was a time where we were seeing 50%. And in my day, I've probably seen once or twice 100%, meaning 100% you won't get it. So something to keep in mind when you're negotiating. Let's move on. We have so much more to still cover. I think we can probably move on from no-fault removals. Change of control. Lee, you touched upon this a little bit and prior, but let's get more specific a bit. So change of control can constitute economic, voting, right? Because you can have economic, you can have 80% of the economics coming your way, but you may not be able to control the way the votes go. How important is it for you when negotiating to have both the economic and voting thresholds both implemented? And then can you chime in, and Monica, please jump in whenever you want to as well. on any carve outs that you think are actually acceptable, right? Because GPs will say, well, if I transfer it to this person, does that really count as a change of control?
Yeah, sure. So this is also one of my kind of hot button topics that I like to see in a document. You want to make sure that the key persons who are named key persons also have, a stake in the general partner and the manager. It's important, I think, again, when you start out initially looking at an LPA, getting a structure chart and understanding really who owns what entities within the sponsor, so that then you can look at the change of control provision and understand what it is you're asking for. I think it's very important to have economics and voting come hand in hand. I think it's a little odd to see them disconnect. And I say that as it relates to what is the GP doing that it's willing to give up one and not the other? What does their documentation look like? And of course, we're not necessarily privy to that. What we try to do and like to do is really limit third-party sales. I think, again, you have to look at the life of the sponsor. If they're just starting out, they're going to want a bucket in order to give employees and future employees incentive. And I think that, our business team is very receptive to that and very open to the idea that an emerging manager is going to need to grow, and we need to give them room to grow. A much larger sponsor that has kind of a couple of funds already in the mix, I think, is probably maybe looking at a third party coming in at some point. So I think it's, you have to get the background. We do try to, at a minimum, like to see those key people and employees sitting at a majority. And I say that as at a minimum, because 49% is a lot to play with. And again, this all goes back to alignment. You just want to make sure they have skin in the game. You want to make sure that, if it hurts you, it hurts them. It's their money. It's our money. And I think that that's just a, important kind of as you approach these documents generally.
Yep.
I agree with that. I think the only thing I would add is, from our standpoint, initially, I was very adamant about this to the point, it's 25% and economic and voting, this whole point that they're following the Investment Advisors Act only constitutes voting, not economic. So you're missing the whole economic component of it. So I was pretty adamant of pushing for that 25%. However, on a practical standpoint, actually one of the GPs got me there, is that, if you look at the third parties that are buying in, like the Dials and the Peters Hill, they want alignment, and they have a vesting cycle that they usually follow in order to keep these people in place at a minimum for that fund. So my view is, if they haven't sold the GP historically, from a business perspective, if they, I'll give them the chance to sell, again, it could be majority, up to majority. But at the same time, I think you're protected for the fund you're in today. Now, I would reevaluate that for the next fund, because at that point they could be vested and they could walk away. But for the particular fund you're in, I think you're okay as it relates to, and that's solely my opinion, but I think from a business perspective, that fund will be okay.
Right. I mean, you certainly have to appreciate a GP's argument. Listen, they're trying to make money. There's oftentimes a great way of doing so by offering interest in the GP. We've seen that happen. We see it happen not just with maybe a total separate fund manager, maybe getting kind of any interest, but just maybe a deal ops person that is going to be facilitating the portfolio companies on the ground floor. And in order to kick off even more of an incentive to get that deal ops person to really do what it needs to do, to have a valid and solid investment at the portfolio company level, offering them an interest in the GP is also helpful. So I want to make it clear, this presentation is not attacking GPs, right? We're talking about things from the perspective of LPs, right? And so, you find yourself on both sides of the line, especially when you're a fund of fund, you are a GP, right? So we appreciate what everyone's trying to do, both on the LP and GP side. We just do our best to make the incentives perfectly aligned so things aren't too out of whack. All right, let's move on to the next slide. Conflicts of interest. Conflicts of interest. This is one that I find myself negotiating quite a bit on. So if you have a situation where a general partner is investing in a portfolio company that is owned by the fund, right? Outside the fund, we have a conflict. If you have a situation where the GP's affiliate wants to enter into any kind of transaction or provide any services to a portfolio company or to the fund, we have a conflict, right? Different ways that these things get dealt with in the LPA. Sometimes you might see if these are done in a way where the fund or the portfolio company enters into this conflict transaction on terms that are as favorable as they would be, right? Or maybe even more favorable as they would be if the fund or the portfolio company entered into the transaction with a third party, we're comfortable there, right? Other situations may say, we always need to see approval from the limited partners, or probably more so the advisory board if there's a conflict of interest. Monica, Lee, what do you like to see in these situations? I mean, do you think that it's important for the advisory board or the limited partners to always be involved in approving these? Do you think that there's some kind of some transactions where it's like, that seems to be an ordinary course, we shouldn't be involved in slowing down the GP? What's your take on these conflicts?
From my standpoint, I think it's materiality, right? So if it's an immaterial situation, like they want to, buy into a company that the fund isn't invested in, and they want to do, a small investment, that's fine. I don't have an issue with that. But if they're, selling one investment from one fund to another fund, I do want to be involved in that discussion. If a company is being taken by the one of the partners, and it's not being offered to the fund, that's an issue too. Yeah. So I think it's fine at the advisory board level, because it's usually a good, we'll get to, who makes up the advisory board, and that's important as well. But I think the advisory board making those decisions and going through those conflicts is acceptable in my opinion.
Yeah, I agree. I think materiality, really, practically speaking, almost has to be the threshold. I don't think the LPAC is up for looking at everything that could potentially be considered a conflict. I will say, though, that our experience generally is that the sponsors are quite scared of tripping up a conflict, and some are quite good at erring on the side of caution and just reaching out to their LPAC, which is usually a small subset of individuals anyways, having the conversation and looking for their kind of sign off, and from their perspective, that if they get that, then they're kind of they got the green light. So generally speaking, we've got pretty good relationships as it relates to that topic.
Right. And I think you raised a really good point there. I mean, you have the terms of the LPA, but then you have the practices of the sponsor. And just because they don't have to necessarily bring what they may think constitutes a conflict of interest, they might just bring it, right, to be in good graces. No GP wants to find themselves in a bad spot and realize they didn't do it. So it's also important when you're negotiating these terms just to think about what kind of GP am I working with, especially if you have a long history with that person, with that GP rather. All right. Side letter do's and don'ts. That was a wonderful conversation, by the way, on key fund agreement terms. There's so much more we could talk about. But let's move on to side letter do's and don'ts. Okay, side letters, for those who may not be totally familiar, are agreements that a limited partner would enter into kind of outside the main limited partnership agreement. So, for example, if you are a regulated insurance company, you are investing in a fund, and you know that you have to disclose certain information to state and federal regulators, you need permission to do so. And the limited partnership agreement will likely say you cannot disclose any confidential information about the fund other than to your employees, perhaps your investors, your advisors, but there are oftentimes provisions in there that would say you can also disclose it to your regulators, right? So an insurance company might say, I need a side letter agreement that says that I can disclose this confidential information without the GP's prior approval, and the GP will not hold it against me for doing so. So you have these side letter agreements. Let's talk about some do's and don'ts. Monica, what are some of the important do's you think exist when it comes to side letter agreements?
I mean, some of the basic ones are, being able to do affiliate transfers. I mean, we have a lot of different legal entities, and at times we need to do transfers. So we ask for those to either not be unreasonably withheld, or
Yep.
To be able to do them without consent.
Yep.
So that's one. Public investments is another one that, we rather them just sell the public investment and sell it instead of giving us the stock. So we put that type of stuff in there.
Yep.
Like you noted in the deck, the MFN, making sure that we get the MFN provisions and have a right, at least at our level, or anything that's provided lower, our commitment level, or anything provided lower. So that's a couple of the
Yep.
side letter type requests we ask for.
Wonderful. Lee, you have any, you want to go into any don'ts?
Sure.
Stay away.
Yeah, well, they're probably a little more less specific. I think don't ignore the rationale behind a pushback from the sponsor. I think a lot of times it's really important to understand why. The
Yes.
answer was no. I've had numerous conversations where you realize that they just don't want every LP to elect, and then it becomes a question around, should we make it not MFNable? Should we tap
Yes.
on representation? Is it something that's really specific to us? So,
Yep.
I think having that conversation is really important. Definitely don't throw in the kitchen sink. I think, lawyers talk to their clients, and the clients talk amongst themselves. And I think it's really important to be really practical with what you're asking for, especially given the evolution of side letters. I think, Arinze, you hit on like regulatory issues, which I think, at the beginning of side letters becoming really common, that's what they were really limited to. Nowadays, people throw in everything. And then the question is, how does your MFN compendium look? What's in there, and what can you get out of it? So, I think it's try to ask for what you need.
Yep.
And depending again on your commitment, the size of the sponsor, the negotiation leverage, the dynamic, there's so many other factors that go into your assessment of what to ask for and what not to ask for. That I think that's kind of the approach that you have to take.
Agreed. And speaking about MFN, it's important to understand your sponsor's procedures when it comes to MFN, right? You might think, oh, okay, well, after closing, I'll have, after the final closing of the fund, the sponsor will send a list of all the different side letter terms, and I'll have about 30 days or so to let them know what terms I want to select. And we've recently seen in actual LPAs that will include an MFN provision, changing that process up significantly, and maybe even saying something to the effect of, if the side letter term has already been disclosed to the limited partner prior to that limited partner closing in the fund, then that would not constitute a side letter that has provisions that you can select MFN provisions from. And it's just like, wait, what? And you have to be very careful, because it's a combination of probably the GPs and the law firm saying, how do we minimize LPs selecting so much? Let's change the process up. And if you just breeze by that in the LPA, you miss that, you might think that you could have selected some provisions that come your way later, and you realize you can't. So the process is very, very crucial as well. I'm going to stop here real quick and give the second code. Second code is 19433. That's 19433. Okay, on to how to be an effective LPAC member. This isn't a topic I see talked about much, right? I mean, people say, I guess it's always good to be on the limited partner advisory committee or advisory board, right? It's usually a bit of a badge of honor, and GPs will not allow you to be on there unless you have a really good relationship with the GP, or what we see more frequently, only if you invest or commit a certain amount of capital commitment, right? Minimum number. Let's talk about that. Monica, you want to share any tips and tricks when it comes to being an LPAC member that people may not really think about when they're deciding to have a representative represent them on that board?
Well, I think your first line is very key in the fact that, people think they're indemnified as being on the advisory board, and you have to be very careful. I have great lawyers, so I'll plug them a little bit, but you have to be very careful in the language of what the responsibilities are and what the indemnification is, because you could be putting yourself in a position that you're on the hook. And for me, I'm very uncomfortable, even though I've been doing this a long time. So what we tend to do is, ask for an observer seat if available, rather than being a voting member. So that way you avoid, that consequence. So that's one thing from an LPAC standpoint. I think, again, I think you covered most of these things on the slide, Aaron's, as it relates to, the GP having the ability to remove the LPAC member without anyone else's decision. And they're just going to put who they think will
Right.
align with them. And that's not fair. Or if the LPAC's not big enough, right?
Yeah.
So, the minimum is 3. I don't think that's enough, having 3 LPAC members. I think 5 is more reasonable than that. And when the GP is uncomfortable with the LPAC members having an in-camera session. So an in-camera session means where the GP is not part of the discussion. Yep. And the LPAC members talk amongst themselves if there's a situation that they need to deal with. So in those cases too, you want to make sure that you have those types of abilities to have a dialogue with the other members. So those are probably the few that I can opine on, but I think your list is pretty comprehensive here.
I would also add, it's really important, even if you're not on the LPAC, but also if you are, understanding the diversity of the LPAC members. And I say that from the perspective of who and what they're representing. If you're an institutional investor and your entire LPAC is not, it's something to bear in mind that they may not really understand the protection that you need from the LPAC perspective. And so, if it's all foreigners and no representative of the US, they may not care signing off on some kind of tax nuance that doesn't really harm them. So I think it's just, even if you're not on the LPAC, understanding, what entities are represented there, is important.
Excellent points. Excellent points. I mean, listen, don't assume just because you're offered a advisory board seat that you should take it. Right? I mean, the initial reaction is, oh, thank you, GP. But now you have to attend the meetings that you may not feel like attending. From a process standpoint, if you're invested in 40 funds and you're on the board of 40 funds, it's a lot of meetings you have going on there. And even though liability may be restricted, it exists. It does exist. So maybe, to Monica's point, we get an observer seat instead of getting an actual seat on the committee. And keep in mind, we oftentimes see, all right, the limited partner that appoints the advisory board member or the advisory board member itself will not be liable except for bad faith, right? Won't be liable to the fund except for bad faith. That's not always the case. I've certainly seen partnership agreements where some fund managers will have in there all of the other kind of carve outs that pertain to the actual GP, key persons, and the GP itself. And it could be an oversight or not, but it's really important if you're going to get an advisory board seat, you might want to make sure that that limitation is clearly in there. Otherwise, to be liable for gross negligence or something like that as an advisory board member is probably a big no-no. Your team may not be too happy that those are the terms you're relying upon. Okay. Let's move on. Fund restructurings. Monica, I'm going to lean on you a little bit on this one with the continuation fund discussion. So when we're talking about fund restructurings, we're talking about the idea of not the fund just simply going through a traditional cycle, but it doing something a little bit different. Really probably to deal with a situation where we're at the end of the fund's term and the GP is trying to hold on to an investment for a bit longer. And the LPs who are in the fund are like, we've been here long enough. I think we're ready to divest. What do we do? So Monica, I'll let you take the lead on this.
Yeah, so I think the point here is this seems to be, it's not a new phenomenon at all. This creation, historically it was mainly focused on tail ends. So what would happen, as Aaron said, that at the end of the life, you have all these assets that are remaining that they can't do much with. So they wanted to, sell them off. So a secondary manager would come in, price the portfolio and buy out whoever wanted to get bought out. What's happening a little bit differently today from that is it's not the whole portfolio. It's just single assets or a couple of assets that they think are more quality assets. So they're actually selling the quality assets today rather than the dogs that they had been selling before.
Right.
And there's good parts of that and there's bad parts of that. So the good part is, as an investment professional, if there's a manager I want to get into and I can't, and they have this continuation vehicle, which we did with one manager, we got into the continuation vehicle. We were comfortable that the alignment with, so key thing is alignment. Alignment is very important. You want to make sure that the GP is rolling over their carry or their profit share and they're continuing on. Yep. In this one instance, in addition to that, they had another fund investing in it, which could be good or bad depending on if you're already in those funds. But so from that standpoint, it's good. On the other side, the thing you need to be concerned with is now they're selling their good assets to this continuation vehicle. What happens to the assets they didn't sell? And you want to make sure that they get worked through. So and again, you want to make sure that as it relates to incentives and economics, that, what happens to your investment? Are you paying the same amount of fees? Are you paying less fees?
Yep.
Are they resetting their carry? And, is it the same amount of carry on a go forward basis? So there's a lot of considerations and you should look at it almost like a new investment when you're evaluating these continuation funds and whether they make sense for you or not.
Excellent. And, listen, I think that it's helpful to start thinking about this from the outset. Nothing's wrong with having a conversation with the GP and say, listen, what happens if you kind of want to do a continuation fund? What are you thinking about? Would you roll over your carried interest? Where are we with things? And we're going to touch upon that a little bit when we get to LP considerations in the week of COVID-19, but there's no harm in having that kind of early conversation because it's helpful to know what a GP is thinking if it were to find itself in a scenario where it wants to continue a fund in the way that you're describing, Monica.
And the other thing you can kind of talk about up front too is valuation. And
yes,
is it arm's length, or you can potentially embed those things in the document too to make sure that you're getting the proper valuation for these types of assets too.
Exactly. Okay, so let's quickly talk about some considerations in the wake of COVID-19. Myself and my two colleagues, Susan Bernard and Nicole Reeves, actually prepared an article in the Private Equity Law Report really about this topic of saying, hey, we've entered into a global pandemic that no one saw coming, okay? Now, should we take a step back and look at our fund agreements and say, let's think about it, right? Fund managers found themselves in a situation where they might need to start looking at their investment restrictions. Maybe their investment approach is not a great one in light of COVID-19. How far can they step outside of their investment approach when looking at their purpose provision or looking at the baskets they're subject to? All of a sudden, money was a little bit tight. Maybe lenders weren't super excited about lending money out. What's your debt restriction now? Is it 20% of aggregate capital commitments, 25%? Will that 5% difference make a big difference for a GP to hold on to those portfolio companies? And thinking about the kind of GP-led restructurings you talked about, Monica, you get to the end of the fund's term. The valuations of your portfolio companies are phenomenal. And then COVID hits and no one cares anymore. And it's just this automatic 5% reduction. And just because the global economy is at stake, and now your carried interest is at stake, your LP's returns are at stake. What do we do if this happens in year 9 or year 10, right? Taking that step back and I think looking at those terms and having those conversations and looking at your different GPs, maybe some GPs deserve more flexibility because you really believe in them and they're amazing. Maybe other GPs, no, you know what? Forget your no fault removals not being in there. We're putting a no fault removal in there because I really wanted to get out from your fund, not because you were horrible, but listen, you're kind of new to this, or or, you're not the top manager, we're giving you a try. We need a little bit more leeway because we see when COVID-19 hit, how difficult it might have been for maybe LPs to connect and get out with no faults because they were limited by the terms of the GP, of the LPA. Do any of you want to have anything else to add on that? If not, I can move on to Q&A, but please let me know.
I was just going to say, I think back in March when this all hit, we anticipated a standstill. We anticipated an influx of amendment requests, and not to say that we didn't receive those for a variety of the points that you listed out here.
Right.
But, again, given this kind of GP friendly environment, it's a little humorous that, a lot of the documents that they gave the GP a lot more flexibility than they really needed. Maybe came in handy during this global pandemic, because while we did get, requests, I think we had anticipated it would just be across the board. And I think if anything, it gave the business team a kind of, some time to reflect and see how their sponsors did and held up, and also gave the business team some time to reflect on how well, you pivot in terms of our portfolio during a global pandemic, and then they did so quickly and so well. But I think that all of a sudden you're in this environment where, blessing or curse, there's a lot of dry powder out there.
Yes.
And you know what, sponsors are still, they're fundraising and they're raising very large funds. And I think I maybe was a little bit naive in thinking that the impact would be so much greater than it actually has been over the course of these last 9 months. Absolutely.
Let me just dive in real quick, Monica. I want to stop you. I just want to give the code. I know we are at the hour mark. The last code is 47509. That's 47509. Monica, please.
Yeah, sorry. I just want to mention one thing is the one thing you have to be careful of is, you do want to give them the flexibility to get to the other side as it relates to their portfolios. But at the same time, what we're seeing is a lot of financial engineering going on as well with, NAV facilities, extension of sublines. So you need to be careful as it relates to borrowing and it doesn't get out of hand in order to compensate for the time that it has been now added to their portfolio duration, right? So
great point. Okay, so we have one question. Question is this: is there a significant case law on LPAC member liability? Are they considered fiduciaries with respect to their fellow LPs and therefore have duties of care and loyalty to consider? Lee, Monica?
Gosh, off the top of my head, I don't know if I could pull out specific case law on this point. From what I understand, no. I mean, the GP's got the fiduciary duty, and the LPAC member does, doesn't on the books, let's say, have a fiduciary duty. That said, I will say that when it comes to assessing a consent, we do always assess it through the lens of potential litigation liability down the road. I don't think that we can say there's kind of a bright line rule as it relates to that. And we have a number of times actually abstained from signing off on consents specifically for that reason, just to avoid any potential liability issue down the road where we attached our name to a certain action. So, I think it's something that has to be accounted for, but, I'm not a litigator. I don't want to speak out of turn.
Yeah, no, I think I would agree with that. I'm not aware of any case law, but there is a fine line you have to just be mindful of, even though you may not technically have a fiduciary duty. And even though you may not have a fiduciary duty to your fellow LPs in that fund, if you're a fund of funds, you certainly might have a fiduciary duty with respect to your investors. So just because that might not exist at the fund level, don't forget what's happening at your fund level, where that fiduciary duty certainly does exist.
And also just be careful, about the abstaining. If there's a negative consent requirement,
Correct.
You need to make sure that you're not putting yourself in a position that you're agreeing by just abstaining.
Yeah.
Absolutely. Okay, well, that was a wonderful discussion. Lee, Monica, I really appreciate your time. Thank you for your wonderful insight. I'm sure it was very helpful for the listeners. And I think that caps our discussion.
Thank you.
Hope everyone has a great rest of the year. 2020 has been a challenging one for probably everyone, to say the least, but hopefully 2021 will give us a little bit more love this time. All right. It's been wonderful.
Thanks.
Bye-bye.
Bye.